Good evening, everybody, and can I welcome you to this lecture tonight, which is arranged, sponsored in every way due to Don and Suzelle, and to welcome Bob Worcester to come and give it. We're meeting today on the eve of the most significant poll, which I think whichever side you're on is agreed is going to be of far-reaching consequences for Britain in generations, and it is going to be a significant act of democratic politics. And there are a few people better to be here tonight to talk to us tonight about that than Bob. And it's going to be, I know, a terrific talk about the uses of polling in a democratic context. But we're meeting on an extraordinarily sad day for democracy in this Britain. I think most of you will know by now that there was an elected MP shot and stabbed today as she left her constituency surgery. And I think the news has come through in the last 5 minutes that she has died. So I wondered if, and I've sprung this on our chaplain, Alan Doig, at literally a minute's notice, but I thought we should begin by thinking about Jo Cox for a minute. But perhaps, Alan, you could say a prayer that would make us think about her family and about the democracy and the democratic process that we share and that we celebrate, and in a way how lucky we are to be able to settle our differences through democracy. Alan.
Let us pray. We remember before you, O Lord, Jo Cox, MP. We remember those who mourn, her family, all those close to her. We give thanks for her life and work, for her service to this country. Bless her and take her to yourself. Comfort those who mourn. Strengthen us in our service to one another and to you. Go before us, Lord, in all our doings with thy gracious favour, and further us by thy continual help, that in all our works, begun, continued, and ended in thee, we may glorify thy holy name. Through Christ our Lord. Amen. Amen.
Tonight's proceedings, and my job tonight is just to introduce the three people you see on the panel, or the three main people we see on the panel. In order, Suzelle, who has received a Master of Philosophy from Lady Margaret Hall, a Juris Doctor from the University of Virginia School of Law, is a visiting fellow of Lady Margaret Hall, a trustee of the University of Virginia Law School, and was a co-founder of the civil litigation firm Howarth and Smith, which is based in LA. She's a frequent lecturer, an accomplished trial attorney throughout the US, handles major cases for plaintiffs and defendants. She sued NBC this year in a major discrimination trial, where she represented victims of terrorism in a $2 billion case against Iran, which went all the way to the US Supreme Court. She won there, 6.62. And both Suzelle and Don are LMH's lawyers in the US. Don received a Bachelor of Arts from Harvard College, a Juris Doctor from Harvard Law School, a Master's in Public Policy from the Kennedy School at Harvard. He's a visiting fellow also of LMH. He handles, with his wife, high-stakes litigation He handled the estate of Doris Duke, NFL free agency litigation. He's defended major healthcare provider in a $2 billion False Claims Act case. And both of them have endowed the law fellowship for Oxford law graduates, and there are many LMH graduates who have extremely happy memories of being in California and working at LA, and that fellowship's now in its 23rd year. And then Bob Worcester, who is going to be doing the main talk tonight, hardly needs introduction. He was the founder of MORI, which is now Ipsos MORI, which has offices in 87 countries. He was knighted in 2005 in recognition of his outstanding services to political, social and economic research and for his contributions to government policy and programs. He is a former Chancellor of the University of Kent, visiting professor and honorary fellow of the LSE, visiting professor fellow of King's College London, honorary professor, University of Kent, and University of Warwick, and adjunct professor at Kansas University. And he's wearing that badge, which tells us that he was is chairman of the Magna Carta 800th Anniversary Commemoration Committee and deputy chairman of the Magna Carta Trust. So we've got a terrific evening ahead of us. We're going to enjoy it greatly, and I'm now going to hand over to Bob.
Thank you, Alan. And it's such a pleasure to be with you and to see so many friendly faces, some of whom I actually know. And I'm delighted to see and honored to think that you've come to hear what I've got to say about this combination, a tough task that Suzelle and Don have given me to talk about the law, which I've had some acquaintance with. Very close recently, because with the responsibility for leading worldwide the Magna Carta 800th anniversary and as deputy chairman of the Magna Carta Trust, having started with Tom Bingham, and then Harry Wolff as my chairman, and then Nick Phillips, and then Tony Clark, and then David Newberger, and now John Dyson, who's announced his retirement, and I'll be then having yet another Master of the Rolls. But also I had my introduction to the law when some nearly 50 years ago, and fairly young at the time, was asked to serve on the National Board of the American Civil Liberties Union. And it was in the late 60s. And that was a time when the law was challenged, your core values were challenged, the First Amendment was certainly challenged at that time, and it was a challenging time to be in a country that was in many ways so being attacked from all sides, with Detroit and Newark both in flames, with Martin Luther King, with Bobby Kennedy being assassinated, and it was quite a time to have your, as I say, core values tested. Now, what I've tried to do today is to have a primer almost in the use of opinion polls, because I have lectured on this for many years, 12 years to the Graduate Center of Journalism at City University, following the late Hugo Young as the visiting professor there on the use and misuse of opinion polls. So the use in politics is half of my brief. The use in law is the other. I'm going to talk about what is public opinion, its importance in a democracy, and explain what it is that we do and how we do it. To take a minute just to say a bit about this thing that's looming a week away, and the polls that are moving the price of the value of sterling against the dollar and other currencies, moving markets 65 billion, and it's very worrying to me that these rather fragile instruments of measurement are being taken so seriously and being gamed particularly by people who are in a position to move vast sums of money and the value of sterling. So I look just a little bit about the EU referendum, and then I move to its use in law, as I was asked to do, the hurdles that we've been looking at, the English law approach vis-a-vis the U.S. law approach in the use of survey research and opinion polls. Draw a conclusion, and then welcome comments and questions. So what is public opinion? The Oxford International Dictionary has something like 824 words to describe public opinion. But its synthesis is in just these few words, as I define it, as the collective view of a defined population. And every word is very meaningful because the collective view looks at the sample that you are measuring. An opinion poll is nothing more than the collective view of a representative sample of a defined population, whether it's students at Oxford or LSE or King's, whether it is the people who live in the City of London or Greater London or any other defined population that can be used as the universe to understand with limited statistical accuracy the views of those people. And I'll explain what I mean by views in a moment. I first used these and developed these in 1993. Does that say 83? 93, that's correct. In 83, I was chairman of or president, I guess, of the World Association of Public Opinion Research for a couple of years. So going on with that development, that Plato did have a view who defined opinion as being more obscure than knowledge, but clearer than ignorance. And I thought that was a very, very good midpoint to be describing it. But Rousseau said, just as an architect, before erecting a great edifice, observes and sounds out the ground to see if it can support the weight, the wise legislator does not begin by drawing applause by which are good in themselves. I don't know whether I would agree with that or not, but first investigates whether the people for whom they are intended is capable of bearing them. And I would think that rather than either or, we're talking about the combination of those things. And I'll come to my own view about that in a moment. So how would you describe public opinion? Well, one way to do it is an aggregation of individual views. We could do this audience. We could do a hands up, and it would be a sort of opinion poll. I was once asked to define the collective noun for opinion pollsters. And I said, well, it would be a sample of pollsters. Unless you had all of them, then it would be a universe. Public opinion does reflect majority view, but it also reflects and should be looked at carefully to determine the minority beliefs as well. It's found in the clash of group interests, activated public opinion, and that's certainly been going on during this referendum contest. It can be both media and elite opinions. We have been, since 1974, measuring regularly the views of members of Parliament with a small sample, but a systematic sample of MPs, including government ministers and shadow ministers as well, as an elite opinion group. Captains of industry, another one. Journalists, political journalists, business and financial journalists, twice a year, and measuring that sort of an elite opinion and contrasting it often with public opinion to see if it's consonance or dissonance. And public opinion has power, but really it's a fiction. You know, you can't see it, you can't feel it. You can see it on the streets, if there is, as happened to me in 1968, when I happened to be in Paris on the day of La Manifestation. And it was a splendid experiment in public opinion. And 1968 was an important year for many things, but being American and not speaking French and being dressed in a suit, and the only way I could get to where I was going with my my briefcase in hand was to march with the 800,000 who were marching it. And it was frightening to me to think that they were going to turn to me and say, "What are you doing here?" as I just joined a group and marched along with them, because I didn't think I would be able to answer it. And they would think, "Oh, my heavens, he's an American. They're in Vietnam." And they were not popular in 1968 in France, I'll tell you. But it certainly has power, as we're seeing right now. Is it important in a democracy? I do not favor management by opinion poll. Whether you're talking about prime ministers and parliamentarians, whether you're talking about business, or even in my own business, I have never consciously done anything because of the views that I've measured in an opinion poll. Why not? Because I think the role of an opinion poll is to guide better management decision, whether it's a company, in the case of management, or in politics. It should guide them, because I'm convinced, and have been convinced, and have hopefully convinced many others, and hopefully will convince you this evening, that people in power will make better decisions in the knowledge of what people think than in the absence of that knowledge. And I test it many, many times with captains of industry who sit on boards of major companies, and I get them to give me the guesstimate questionnaire answers so that they tell me what they expect to receive in the presentation I'm about to give. And I can guarantee that there will be around a table of 12 or 15 directors of a company who will have collectively not a bad representation of the workers' attitudes that I'm measuring. But there will be 40 or 50 points between the person who is the lowest person in the room on that particular question and the highest. And they'll all go away from a presentation without having done that and say, "Well, I guess we knew that already." But they didn't, clearly. And I've got many surveys of that sort that will show that. Respect for public opinions gave a safeguard against tyranny. The week that the task force sailed to the Falklands, Tony Benn stood up in the House of Commons and, waving a sheaf of letters in his hand, said, "Public opinion is swinging massively against the war." I quote directly, quote, unquote. And the next day, The Economist came out with our survey that showed 78% of the British people were in favor of the task force going to the Falkland Islands. Now, I would not say that my late former friend, Tony Benn, one of the most courteous of men, is tyranny. But I thought it was a good example to use with you because almost everybody here would have known it. In fact, I was telling the story earlier of being asked by David Butler. Is David in the room, by the way? The last time I was here, time before last, it was at Exeter, and David was there in the front row. So I suspect if he had been here today, he would be in the front row. And David rang up and said, "This is my last term at Nuffield." I said, "Yes." He said, "Would you give my last guest lecture?" I said, I'm really so honored, Tony. Why me? Tony Benn couldn't do it, he said. Public opinion can be mobilized. And what they're trying to do in both sides of the referendum question is to mobilize the forces, get them out to vote, get them to register, particularly the young people. And public opinion does provide clues about the culture of a country. And one of the challenges that I've had in my career has been in Trinidad. in the Caribbean, Trinidad and Tobago, where I worked for the Prime Minister of one party for 8 years, and then the Prime Minister for the other party Prime Minister for the next 5 years. And it's a country split not by right-left as we know the political spectrum, but by Afro-Trinidadians and Indo-Trinidadians. And it was a whole different culture for me to get to understand. And vox populi, vox deo? Well, as the Latin saying goes, vox populi, vox dei. The voice of the people is supposed to be equal to the voice of God. Yet public opinion is also believed to be like an ignorant, vulgar person who reproves everyone and talks most of what he understands least. As Hegel quoted Italian Renaissance poet Lodovico Aristo, pardon my pronunciation. I've taken that from one wonderful book, which almost no one has ever heard of, by a scholar that nobody's ever heard of, a Slovenian named Slavo Splešel, and he's had me speak to master class in his university in 2001, but that was his book in 2001. So what is it we do? We measure perceptions, not fact. And as the first century slave philosopher said, perceptions are truth because people believe them. And it's no more true anywhere than in a political context. 5 things that we measure with the tools of our trade. We measure people's behavior, what they do. And that's fairly easy, but sometimes we're misled, not intentionally, but because people haven't remembered what it is they did at a point in time. We measure their knowledge, what they know or think they know. Could I ask for hands up, those of you who have never been polled and you don't know anybody who's ever been polled? Hands up, please. Well, I would guess it's at least half the audience. Now, those of you who have been polled, put up your hands. Now keep them up. The rest of you look around. You'll never again be able to say that you've never been polled and you don't know anybody who's ever been polled. Gotcha! So we measure their knowledge. Now, I use this illustration of the sea to describe the next point, their views, because rather too poetic for academic adoption, I define people's views as their opinions, their attitudes, and their values. Opinions, the ripples on the surface of public consciousness, easily blown about by the winds of politicians, of the media, Alan, of the people they talk to, of their priests, of their vicars and priests, their friends and family. Lightly held and not particularly of importance to them or their family. And deeper are their attitudes. And attitudes are the things that they have talked about with these people, that they have concerns about. And when I give talks to people in the party conferences in the autumn, as I have been doing every year for GovNet, the company I sit on the board of, I use this definition. I say to these audiences, do you want to know, mainly leaders and shadow leaders of local councils seem to come to those lectures. And of course, they're the majority of the people who come to those conferences. And I say, you want to turn an opinion into an attitude? Forget to collect the rubbish for 2 weeks. That will turn an opinion into an attitude. And if they do have an attitude, you better believe that it's going to affect their behavior in elections if they really get upset. And their values are the deepest of all, the great tides that are below the surface of the sea. And those tides are belief in God, euthanasia, abortion, the death penalty, things that we talk about at university and even high school, using my vernacular and American parlance, that are rarely changed after the age of about 25. So what's the role of social surveys and polls in a democracy? Lippmann talked about it. Social control depends upon the devising methods by which acts of public opinion and industrial directors are measured. But the working, this is 1922, the working out of such standards and such audits has only begun. And that was virtually 100 years ago. And we've been working on them ever since, and we haven't got it right yet. I won't go on to that one. It's a simple business, however. All you have to do is ask the right questions of the right sample and add up the answers correctly. But the toughest thing is report them knowledgeably and accurately, and make sure that the journalists that you're dealing with do accurately report what the meaning is behind the numbers. So firstly, the art of asking questions. You want to maintain the respondent's cooperation and involvement. You want the trust of the people you're talking to. You're asking them to give their anonymous views and behavior and knowledge in answering questions that are precisely framed in such a way that they're not double-barreled questions or even triple-barreled questions, that they're not using language that is not easily understood, as I will say. So communicating to the respondent, helping them to work out how to answer the questions. They're asking for help often. And I'm not sure what you mean. And you've got to be very careful with the way that's handled. I did not like the proposal, should Scotland become a separate country, because you can manipulate the answers to this, not in a referendum, interestingly enough, but in a survey. Because well, I'll speak to that in a minute, and I've gotten an even better example. But also making the interviewer's task easier and providing a basis for data processing. But my favorite biased question was asked by Gallup in their first year in 1937 in this country. Are you in favor of direct retaliatory action against Franco's piracy? How's that for a cracker? In 11 words, they broke 5 rules of good questionnaire construction. So I said, the art of asking questions, the science of sampling. We need to ensure representation. If it's not a representative sample, you might as well throw it away. And even the BBC used to do these massive telephone polls, not telephone polls, phone-in polls. I called them phony polls, phone-e polls, which had no validity whatsoever. And one time the proprietor of the Daily Express said to his editor at the time, Charles Winter, or his editor-in-chief, Charles Winter, the late Charles Winter, that these opinion polls that you keep commissioning Bob to do, they only ask 1,000 or 2,000 people. We'll put a coupon in the newspaper, and we'll probably get 10,000. They didn't get 10,000. They got, I think it was 82,000 responses on the death penalty. And they were like 89% in favor. But Charles commissioned me to do a poll at the same time. And in the way that particular question was asked, because you can manipulate all sorts of questions about the death penalty, the most extreme that I came up with was of a convicted child murderer who kills a prison guard while escaping from life sentence. And it's like 90% in favor. A fit of passion in a certain circumstance, more correctly described than that gentle way of putting it, was down around 50%. So that's what you had. And I remember Derek Jameson ringing me up one time and saying, we want a poll on hanging. And I said 83%. He said, no, I don't want the answer. I want to do the poll. Ensure replicability. One of the most important things is to do longitudinal studies. We have been measuring trust in all sorts of occupations and organizations, like banks, like civil servants, like doctors, like pollsters, like journalists. I won't say where journalists come out. And you want to be able to carve the questions so precisely that you can trust throughout many decades. We first started that series for the Sunday Times in 1983. We're still doing it today, every year. And it was used the other day in a meeting of the Institute of Business Ethics. Minimize possibility of interview bias. Make the interview's task easier, as I said before, but it applies here in the science of sampling as well, and provide a data basis for comparison and for data processing. 8 ways of analyzing the data. We have to add up the figures correctly, but we want to compare subgroups, men versus women, young people versus older people. Longitudinal comparisons, over time, normative comparisons against things that we know about, ideal versus actual comparisons. What do you think? And we've got this whole series running of the misperceptions of people in this country who wildly estimate the number of immigrants to the country compared to what the actuality is. Benchmark comparisons, expectation versus actual findings, which I described earlier, and international comparisons, such as with the World Values Survey that was done in 54 countries, the last wave. So switching then to politics, just a couple of questions here, not to do with the voting intention today, although our poll this morning was a 5% swing. 5 people in 100, that's what swing means. 5 people in 100 from last month to this month have changed from staying in, remaining, to leaving the EU. And we had just this afternoon in the Evening Standard, but released at 9 o'clock this morning. But to look at this, here is what you see as the most and other important issues facing Britain today. That immigration and immigrants was 46%, is it? Yes, 34% for the NHS and the economy. And Europe, the European Union, it's an open-ended question, so they can answer whatever they want, and it's all coded to fit into these categories, 23%, and that was in April, wasn't it? And then, I don't have it in May, but it did change in May, and we measured it because that was the longitudinal measure that we've been having. And here you have another question that's interesting and useful. 44% said that they effectively trusted David Cameron to speak on it, or wished them to speak on it. Boris Johnson, Theresa May, George Osborne, those will have changed. Jeremy Corbyn in Labour Red there at 27%. And Nicola Sturgeon in the orange of the Scottish National Party, down at 22%. And this one, I won't dwell on what it is, it's just that we look at Conservative, Labour, Lib Dem supporters and whether they are in favor of doing this, how they would vote, and men, women, age, and social class. And this is one that looks specifically at starting with all who gave a voting intention, and that was nearly 9 people in 10, and there's not going to be a 90% turnout. So you filter out those people who are certain to vote and who voted in the last election, and you get it down, and that moves the proportion of people who want out in the red going from 41% to 46%. That kind of analysis can be very valuable. That's another one that's just a more detailed scale. So let me swing to the law in the last couple of minutes to talk about the use of public polling in law. And there's a reluctance to allow survey evidence in court and in tribunals. The question of hearsay. Do the hearsay rules apply or not? Because you do not have the witness in the stand. You have the pollster or survey researcher in the stand, or market researcher. Some of the most interesting things we have done has been passing off questions that have depended on whether or not the public, the buyers, in the case that I'm thinking of, when there was a store who set up called Greenpeace, and we were asked by Greenpeace. It was a very high, good store. There's nothing the matter with the store, but there was something the matter with the name, because I designed a sample for them that was for people coming out of the store carrying a shopping bag with Greenpeace on it. And we asked them how much, if anything, they thought went to Greenpeace, the environmental charity. And we got, I don't remember the figure, 15% roughly, said that they thought. And that quickly settled out of court. And they agreed to change the name of the store because they were passing off, and there wasn't any question about it. It didn't go to a verdict, it didn't go to a jury, because it didn't need to. So as far as my client was concerned, they got what they wanted with one survey, and it cost them a lot less than if they'd gone to court, that's for sure. Some jurists won't understand it because it is a complicated business. Some lawyers don't either, and that comes clear to me frequently in these discussions. And expert witnesses might not. But when I was the expert witness for Legal in General in the tribunal, Legal in General versus the FSA, it was an amazing experience because one of the things, and this will come up in a moment from the law, I said it was an outrageous price that was paid by the FSA for the survey they had conducted, which wasn't very good. And the barrister broke the first rule that I understand you're taught in the first day of being a barrister. Don't ask the question you don't know the answer is going to be. And I said, he said, you have said that this fee of like £850,000, how much would you have charged? Thinking I'd say, well, roughly the same or something like that. And I said, well, I can't be sure without seeing the entire brief, but I'd say more like 150,000. And the chap just came back. But then he had his own expert witness to counter me on the stand. And he said to him, is this the worst survey you've ever seen? And his own expert witness said, no, but it's certainly in the bottom quartile. Wow. Qualitative. If there's no qualitative aspect to it, why? Because the most valuable question that we can ask is when we have, in a questionnaire, in a representative sample, if we find that somebody says something, we can say in that, why do you say that? And we can get a very, very good feel for it, because qualitative is feeling. It's the whys, and quantitative is the whats, or the whens, or the whos. Now, just quick summary of these. Hearsay, in the UK, means a statement made otherwise by a person while giving oral evidence in proceedings which is tendered as evidence of the matter stated, Civil Evidence Act in 1995. Or, in the USA, means a statement the declarant does not make while testifying at a current trial or hearing, and a party offers in evidence to prove the truth of the matter asserted in the statement. Federal Rules of Evidence, FRE, 801C. Now, what's the difference here? I think I've got to stand away and read it up on the screen with you. But on the left-hand side is the UK. Civil proceedings evidence shall not be excluded on the ground that's hearsay. Focus on the weight of evidence. Considerations under the CVA determine weight of evidence, including whether the person who made the original statement reasonably could have been adduced, whether the evidence involves multiple hearsay. And the hearsay is not admissible unless any of the following provides otherwise. Federal statute, these rules, other rules. Don and Suzelle are going to talk about these as well at more length, focused on admissibility rather than weight, an exception to the FRE rule. A high bar, to 2012, considered that even if the evidence is technically admissible, the judge should not let it in unless satisfied that it would be valuable, unlikely utility of the evidence justifies the cost, which is where I was coming from with the Legal in General, FSA. In deciding whether to give permission, the court must evaluate the results of whatever material is placed before it. Only if the court is satisfied that the evidence is likely to be of real value should permission be given. Even then, the court must be satisfied that the value justifies the cost. Another approach possible to conduct fair surveys which lead to responses which can be relied on and which are of such value that it is appropriate for them to be admitted in evidence, and this evidence may be even capable of determining the outcome of a case, and indeed has been. Sometimes used substantial grounds for believing that there will be a real risk of this or some other sort of flagrant injustice. There is a suitable case for survey evidence to be adduced in Champaign, Louis Roederer versus Garcia, Mr. Justice Henderson, and other times dismissed as hearsay in the trademark application for Oasis stores, and the KGS surveys produce hearsay evidence, much of it opinion evidence. Much hearsay evidence is extremely valuable, but before accepting as valuable, one needs to have evidence of its value. And I think evidence that it was properly conducted. I would have added that had I been the judge on that case. And a difficult start in the U.S. That was a long time ago, 1928. Expert opinions may in some cases be based upon personal knowledge gained from observation. The rule is well established. Hearsay in the form of information gained from the statement of others outside the courtroom is not such personal knowledge, nor may it be the basis of an expert opinion. So there you have 1928. Well, it was about 1928 that George Gallup and Claude Robinson were graduate students at Northwestern University working toward their PhD, and their PhD was in journalism. They were journalists, not opinion pollsters at that time, was in survey research measuring newspaper readership and developing it. In 1937, they set up a company in 1934, I think it was, in New York City, American Institute of Public Opinion. Later became the Gallup poll as Gallup and Robinson split when the Merchandise Mart, the American Jewish Congress, and the third group asked them to ride questions on what we now know as an omnibus, those quantitative surveys measuring newspaper readership, and they hitchhiked questions, and George Gallup said, no, I'm a journalist, not an opinion pollster. And Claude Robinson split then and set up Opinion Research Corporation, where I cut my teeth. I'll skip this one and come forward to a more promising treatment in 1963. Judge Feinberg, surveys A, B, and C were scientifically conducted by a competent and professional research firm, so that's the quality test. I conclude, therefore, that the surveys are admissible to show secondary meaning for the shape and appearance of the Zippo, Standard, and slim lighters, and the likelihood of confusion between these lighters and the Rogers. So a great deal of the work that we do in the law with lawyers is this sort of approach. And an expert may base an opinion on facts or data in the case that the expert has been made of personally observed. I'll let our hosts this evening, our sponsors this evening, do that. But the modern rule in FRE 703, a more satisfactory basis for ruling on admissibility of public opinion poll evidence. Now we're getting right to the heart of it. Attention is directed to the validity of the techniques employed, that is quality test again, rather than to relatively fruitless inquiries into whether hearsay is involved. So I'd like to take comments and questions, but before I do, I think let me turn over to my partners in crime here and come back at the end.
So given the time constraints we have tonight, I want to present two limited propositions for you to think about. First, and we're talking about a law and polling, the use and misuse, the admissibility of polling and surveys in the law. I want you to compare that to other evidence that's very well accepted in the legal system and ask yourself the question, should there be a difference between these forms of evidence? Is there a qualitative difference between the forms of evidence? And then second, because Sir Robert has quite properly pointed out that polling and surveys are resisted in the law, much more difficult to get in than the other routine forms of evidence. Why is that the case? Why has that been the case? Because that gives us some insight into whether or not it's likely to change. So those are the two propositions that I want to consider this evening, and I want to thank the principal for the introduction. It was actually a pleasant change because I've just been introduced at the Texas Lawyers Association meeting where Suzelle and I were speaking before coming here. And I was introduced as a model lawyer and a warm speaker. So I looked it up on the way over. And model lawyer, actually, if you look up model, it means a small copy of the original. I looked up warm. It says not so hot. So it was a great pleasure to have the change tonight. Let's go on to the, I'm not going to spend a lot of time on this one. You've heard that from Sir Robert. The fundamental issue when we're talking about hearsay is this evidence going to be trustworthy? Is it really going to mean what it says? And so if you think about what a hearsay question is, a hearsay answer to a question, it's a statement, as Sir Robert says, that's made out of court, so not by the witness in court, that's being offered to prove the truth of what that person said outside of court. Now you can see right away that that is not going to be subject to the normal sorts of cross-examinations and twisting it and turning it and drilling down that you could do if you had the witness there. What did he really hear? What did he really see? What was his angle of perception? What's his memory? You can test those things on cross-examination, but if a witness is testifying about something who's not there in court, a statement he heard outside of court, then for many reasons it's resisted in the law. And you could tell Sir Robert had exceptions up there, and any law student who's had to work over those exceptions knows that these excited utterances, dying declaration, and so forth, they're exceptions because there's a perception that those are more likely to be true even though they're made out of court. So we're looking to the test of whether this evidence is really, is you going to be able to put it into the crucible and give it the acid test to decide whether it should stand up, hold its head up in court. That's what many of the problems that have been raised with this kind of survey evidence are. Next slide. Sir Robert went through these, so I won't spend time on them, but I will point out that you can divide the universe of these sorts of issues into the objective and the subjective. If, for example, I were testing or reporting on a survey of the average height of students at Oxford, then, and I took the data that had their records, their medical records or something as my source, I still got to get the proper universe and a representative sample and analyzed in accordance with accepted principles and accurately reported, but I don't have the problems, the subjective problems that are so difficult of how the question is asked. You saw some of those issues in some of Sir Robert's examples, whether they were sound interviewing procedures. Those are true if I'm getting an opinion poll on Brexit, for example. I'm not looking at hard data to start with and reporting it to project to a larger sample, but I'm actually generating the data through my questions. Next. That opens the door when we talk about projecting this to confidence intervals. This is the formula for confidence intervals that a statistician might present or Sir Robert might testify about, to be able to say that this poll, for the conclusion that it's given, or this survey or this statistical evidence, supports this proposition. And if you think about that, and I've got two hypotheticals here, one would be, has Alan Rusbridger been an addition, a positive addition here at Lady Margaret Hall? If my survey came out at 75% saying yes, with a 5% confidence interval, meaning it might be 5% more or less, I'm on pretty good grounds to say up around 3/4, 2/3 believe that. If my survey came out, say, at 53% on the same question, with the same confidence intervals on both sides, then you can see the possibility that what we're looking at when we pick that central figure of 53 is really 48%. And that may not be very significant in terms of what people are going to do at LMH and their reaction to Alan Rusbridger. But if you're in court, so much is determined by whether a proposition is more likely true than not. And so when we get down to a survey that hovers around the border, it leaves open the possibility that it's not proving that conclusion. A second example I like to use is with a pregnancy test, for example. If you had a pregnancy test that you could buy in a grocery store, in a supermarket, that was just a quick and simple pregnancy test, then it might well be sufficient if that pregnancy test showed 95% of the time it gave you the right answer. You'd know, and you could prepare you were pregnant or you weren't, and you might be surprised 5% of the time. You might be pregnant when it said you weren't, or the reverse. And it probably wouldn't have dramatic consequences for you. But often in a court of law, if, for example, we're working with causation issues, think about epidemiology, where a doctor would testify or a medical scientist would testify about whether smoking causes lung cancer. I might be able to say as a general proposition, if it's a 95% basis on the survey, that I'm willing to give an opinion that smoking leads to lung cancer. But if I were asking about the individual in this case, is his lung cancer from the smoking or from other factors, then as a judge or juror listening to the evidence on that question, it might be less important to me to know that 95% of the time it was and 5% of the time it wasn't, and I might be asking myself instead, have I got one of the 5 here or one of the 95? And I want to know the evidence that shows me which camp this is in, even though I know that one is a lot larger. Let's go to the next slide. Now, I want you to compare. One of the things about statistical evidence when we put in the projections, the results of the survey, is that we can calculate that percentage, like the 95% that I was showing. You can calculate some statistical percentage that what we're seeing is the result of chance or other factors rather than what we're really trying to test. And so that may be small or it may be large, depending on the confidence in the survey. But there will be such a residual probability in that kind of evidence. People think in the law, and have thought for a long time, that there's not that sort of same degree of probability in other sorts of evidence. Think about the hard kinds of evidence. Eyewitness testimony. I'll show you what the law has said about that in a moment. Confessions, forensic evidence, ballistics, blood tests, DNA, and so forth. Documentary evidence, a silent witness, something in writing that doesn't change its testimony because it's looking for a certain end or because it's forgotten. It's there in writing. Those have been well accepted in the law for a long time. Next slide. These are 2 quotes from cases in the United States. Nothing more convincing than a human being takes a stand and says, that's the one. That's the man who did it. The most compelling, this is from our Miranda case. You remember Miranda in the Supreme Court in the United States? It's the case that caused the warnings to be given. You have a right to remain silent. If you speak, it can be used against you. You have a right to attorney. You can get one if the state will appoint one. It may not be very effective, but you get one if they appoint one for you. So our Miranda warnings come from this case. And what the justices said in this case, the most compelling possible evidence of guilt is a confession. All right? Now, with the advent of such things as DNA testing, we have in recent years, and we've actually gone back and unwound many convictions in the U.S. on the basis of this testing. Next slide. So a group called the Innocence Project, very reputable group in the United States, did a series of tests with DNA on closed cases, on people who were in prison, innocent or guilty. And what they found was that the DNA evidence exonerated a number of the people who had been convicted of the crimes, clearly exonerated them. These percentages, by the way, don't add up because it was whether that was a contributing factor. It may mean that, that was, in one case, there was both an error in forensics and an eyewitness misidentification. But in 72% of the cases where they found that it exonerated someone, not 72% of the cases they looked at, 72% of the cases where it was wrong, It was because of eyewitness misidentification, faulty memories, pressure to testify in a particular way, a desire to please when they testify. All of these things a psychologist could tell you about that would affect eyewitness identification, and many convictions infected by this. Error in forensics, I'll show you something else about that in a moment. False confessions. Confessions, again, where someone is either pressured or confesses because it seems to be the thing to do in the circumstances, and where they weren't guilty of the crime. Next slide. This is a famous such case in our country, the Central Park Jogger case. Remember the young woman who was raped in the park, raped and murdered, I think, in the park. Confession of this man, 1989, and the Central Park 5 with him. Prolonged interrogation, 14 years old, confessed, spent 8 years in jail. Next slide. After 8 years, he's released. This man, who's already in jail, convicted murderer and rapist, confesses to the crime, matches by the DNA evidence, and the other one is exonerated. Conviction was based on standard, accepted forms of testimony. Confession, identification, the things that we routinely accept, which themselves have in them large margins of error, although not as explicitly stated as with survey and statistical projections. Next slide. This is just another one, but I like it because it shows that even what I just used for the Innocence Project, the DNA testing, this was DNA testing of hair samples. They match hair sample to a accused. And they had tremendous success, the FBI, in matching these hair samples to the accused, including this man's sample. He spent 25 years in jail until he was exonerated by other evidence. And it caused a review of the FBI labs. And they found that over an 8-year period, there had been in 28 out of 30 FBI labs a high number, I don't have the percentages, of mismatches, which they conceded were mismatches. So even the DNA evidence, which is thought to be the gold standard, can be misused, misunderstood. It's said in our country it was evidence that there is nothing which is foolproof to a sufficiently talented fool. Right? Next slide. We used to say a picture is worth 1,000 words, right? We grew up believing that. Picture is worth 1,000 words. You know today, by what they can do with Photoshop, that that's not true. So this woman, for example, was recently disbarred in California because she had on her website, you see in the top picture, she's with President Obama. Here she is with Donald Trump. It was not quite clear to me from the State Bar opinion whether she was disbarred for misrepresenting she had associated with these people or for her judgment and taste. But in any event, she was disbarred. Over on the right is a famous picture that went viral. The woodpecker being hitched a ride from a weasel. And after that went viral as a presentation of what had really happened, this picture went viral, at least the first part of it, with you can't see it from very well, Vladimir Putin on top of the weasel being pursued by a Star Wars figure. So pictures today, far from being a picture worth 1,000 words, are very, very suspect because of the ability to manipulate them. And much now will go back to depending on the testimony of the person who's validating the picture. Next slide. All right. So, wrapping it up, why this resistance? Why the resistance to the survey evidence and the statistical projections? Lots of ideas. They're not familiar to us. But think of these other things which were not familiar to most of us until fairly recently. Did you embrace online shopping right away? Now it's Amazon is the place to go in our country. Laptops in lectures and meetings. I can remember as a lawyer when the laptop started coming in, seeing somebody at a table with 20 people at a large meeting with a laptop, and I thought, what does he think he is, the court reporter? What's he bring in the laptop? You go today and the students or the meetings, everybody has a laptop. So we can adjust to a number of these things. Social media is another example of something completely unfamiliar to most of us. Some of us are old enough that we won't have to pay a lot of attention to it. To others of you, it'll be second nature throughout your career. Is that the case with statistical sampling, projections, surveys? Next slide. And I'll wrap it up with this and give Suzelle a few minutes to get some questions. But I go back to the formula for testing the validity of the projection of the sample, for saying that because this small group answered this way, does that mean it is true for this larger population? Can I legitimately project with all of these tests? And this is the formula, the mathematical formula. And there, I think, is a key, because it's a mathematical formula. So when we test these things in court as trial lawyers, we're not testing them in front of the Supreme Court or the appellate courts first. When Sir Robert Worcester comes in to testify, he's testifying before a judge, generally. A judge, maybe a judge with a jury. So I want you to think about old Judge Benchbottom. And he's sitting on the bench. And he went into law because he was never very good at math or statistics or science, and he didn't want to do heavy lifting. And so law seemed like the natural avenue. Now, Judge Benchbottom, his favorite expressions are move along, counsel, and judicial discretion, and so forth. He's never going to catch a glimpse of the footsteps of the luminaries of the law, the Holmes, the Cardozos, the Manses. He's never going to see that. But he's there on the bench day in and day out. And when he starts hearing evidence that's unfamiliar to him, mathematical evidence, probabilities, statistics, projections, his eyes glaze over, and he goes back to the times when he came in, those unhappy occasions, when he came in front of his father with a report card that showed his grades in science and math, and attempting to justify those things. So the easiest response for him, not unlike the young boy who came home in our country with 4 F's and a D, and was asked by his father how he explained that. He said, well, Father, it looks like I concentrated too much in one subject. The easiest solution to not having to go back to those painful times is to say things to this wizard that's come in, this Sir Robert, or his one of his clones somewhere, I don't get that high, but someone who follows in his footsteps, and say, overruled, excluded, not admitted, because now he's back away from exactly the things that he wanted to avoid by going into law. So how much of this is because as lawyers we think with one side of the brain, we don't understand so many of these mathematical and statistical things, and as judges, who are a subset of that group, is that really what's happening here? Or as some wag said in our country, I think it was Joe DiMaggio said about people in that situation, you know, if you don't think too well, don't think too much, right? Is that what's going on here? So I leave you with those two questions. Is this really an area that we should be distinguishing so sharply from other admissible evidence that we use every day? And why? What are the factors that have been pulling this back from letting us bring it in and be tested freely on both sides? Because it's always subject to cross-examination, the person who did the surveys, who projected them and so forth, and to an opposing expert on the other side. And will that change over time? What are the reasons that are holding it back? Thanks very much.
So I am aware that I'm the only thing standing between you and your champagne and drinks. So I'm going to be very brief, but Don and Sir Robert have covered so eloquently and thoroughly the points that there are just a few comments that I want to make, and then I know we all want to ask Sir Robert a couple of questions in this very interesting times that we're living in. One of the nice things about this tradition of this lecture and drinks and dinner is that there will be time for those of you who are joining us for drinks to talk to the panel and ask questions. So we'll take a couple, but let me make a couple of points. I'm a trial lawyer, as most of you know, closest thing to a British barrister in the United States. That's what Don and I do. We go in front of judges and juries. That's our stock and trade. And from a trial lawyer's point of view, I am of the belief, and have also been convinced, as I think maybe you were, by both Sir Robert and Don's comments, that it's not so much anymore about statistics and survey evidence not being admitted by the judiciary or not being even embraced, but it's a question of how the studies are done. Are they done scientifically, appropriately? And I read the cases that were up on the screen, the citations. Most of those cases, even in Britain, the heart of it, when the judge is ruling survey or statistical or opinion poll evidence out, is because the survey wasn't done properly and accurately. So those of you who are law students and those of you who are lawyers, the message here is when you hire Sir Robert, for example, and you pay, what was it, 150,000 pounds, Bob? Or whatever, 850,000 pounds. When you do that, you need to be sure that you're getting someone who's qualified to give you your money's worth. And if you do, and if you as the lawyer understand the process and understand the proper legal arguments to make to substantiate the introduction of the evidence, then I submit to you 90% of the time that evidence will be admitted. And in fact, in the United States, there was a period of time where the courts were reluctant. Now it's fairly well embraced. It's even in the judicial handbook and the federal rules comments that Sir Robert alluded to. So the evidence, if it's done right, should be admitted. How important is survey and political opinion, public opinion polls in the United States? Well, the Supreme Court of the United States has used survey evidence to justify its own opinion and ruling in one of the most important political cases that's been decided in the United States, Bush versus Gore. Bush versus Gore, as you know, really essentially decided who the President of the United States would be, had to do with the Florida election. But the United States Supreme Court said in supporting its opinion that nationwide statistics reveal that only an estimated 2% of ballots cast do not register votes for presidential candidates. So the Supreme Court, it's not so important to me what that opinion poll or the statistics or whether they got it right or wrong, but the United States Supreme Court said in its opinion, we're justified in making our decision about not to allow a recount because of our research into public opinions and public opinion polls. One of the examples of the use of public opinions and opinion polls in the United States that's very significant to us as trial lawyers has to do with the fair trial. And Don and I have come before this body before and talked about fair trials and fair trials in the United Kingdom and in the United States. And as you know, in the civil arena in the United States, we still have jury trials. In the UK, very limited jury trials in civil arena, but in the criminal area, you still have the right to a jury trial, as we do in the United States. So we often come up with the question is presented to us as lawyers, can we get a fair trial for these particular parties, these particular people, the plaintiff or the defendant, in the particular venue? We have tonight, in addition to Sir Robert, we have a jury consultant, the president of Trial Partners from Los Angeles, Lee Miles. She'll be with us for dinner. But Lee is a very well-respected jury consultant. She does a lot of opinion polling, and she helped us with a case where we represent, Don and I represent, the dairy industry of Utah. So we represent the cattle farmers and the cow farmers, the dairy industry. That's in a case where they're the plaintiffs. The defendant is the local power plant, which is releasing electricity into the ground, and take my word for it, it's hurting the cows. Cows don't like electricity. When they get a shock that goes through the water tables, that it reduces their milk production and it reduces their immune system, so they die. So this case has been going on for 12 years, and it's a mega battle between two industries. We represent the David, the power industry is the Goliath. So we were in Utah, and we got sent to the county. This is a state court case. We got sent to the county where the power plant employs about 95% of the people in the county. So we presented, with Lee's help, to the judge that just based on employment records, we couldn't get a fair trial in this particular county. Rural counties, send us to Salt Lake City or somewhere where virtually everybody isn't hired by the power plant. The judge took it under consideration. He eventually said no, that he thought that it could all be taken care of in the voir dire process, the questioning of the jury. We tried a 2-month trial, and it turned out that in the last week of trial, one of the jurors asked to speak to the judge privately. She went in and she said that she had been pressured since the beginning of the trial by her neighbors, her mother, her husband, who said, if you vote for the farmers in this case, we'll all lose our jobs, which was the point we were trying to make in the beginning. So that case has come back, and now we are going before the judge, Bob, and we're telling the judge we need to do a thorough public opinion poll, a survey, and ask questions about people's attitudes about the power plant, the farmers, because this time we want to get the judge's approval at the beginning. If we get the judge's approval and his investment in it, in the poll at the beginning, that he approves the scientific process, then we think we can show him what we think is clear and common sense, that we can't get a fair trial in that venue. But it can be very, very significant on that issue in the United States. What about judges? So one of the things I didn't hear Bob say, Sir Robert say, and it may just not have been on the list, but what about judges and judge bias? Has somebody taken polls of judges and seen, whether demographics of a particular judge makes a judge likely to vote this way or that way? I haven't ever seen one, but I do know that a lot of highly educated Oxford professors and students and graduates are of the opinion that a judge is not susceptible to the same sorts of inherent biases that we might fear from a jury. And I will cite to you Richard Dawkins, who's a friend and a very renowned professor at Oxford. And Richard wrote a book called The Devil's Chaplain, which is an interesting title, and it's a book of essays, and we could have a whole discussion about that. But Richard is never in doubt. He's not a lawyer, but he wrote an essay about judges and juries, and his conclusion was that any educated person who was charged with a crime or had a case would want to go in front of a judge, not a jury. Why? Because judges are more educated, they're trained to be neutral, that's part of their code and their oath. And so a judge, obviously, if you believe those facts, would be a better trier of fact than juries, who are people often very, very low educations, sometimes none, questions about their biases as well. So shouldn't everybody in this room always prefer a judge to a jury if we had a matter that we wanted to be decided? Well, I had read Richard's essay, and he came to one of our lectures a couple of years ago, and I'd been waiting to ask him this question. So I said, Professor Dawkins, I read your essay, and here's the example I want to give you, the hypothetical. You, Richard Dawkins, have been charged with, let's say it's murder. You've been charged with murder, and you have the choice between a judge and a jury. And you're given the information that the judge that you've been assigned to knows about Richard Dawkins, knows your writings, knows your position as an evangelical atheist, which he's famous for in debates and very proud of. And you find out that your judge is in fact a devout Catholic, and that this judge has read your writings attacking the Catholic Church and other religious institutions. Now, do you want that judge or do you want a jury? And Professor Dawkins said, well, Suzelle, I never thought of it that way. So I want to see if we can get some surveys of judges, Lord Mance. I would like to see what happens if we survey judges and their demographics and their characteristics, and can we predict if a certain kind of judge with certain characteristics would be more likely to vote one way or another way in our case. I'm going to quote The Guardian. Lady Hale was interviewed by The Guardian, and she was asked, do judges represent the entirety of the public opinion in Great Britain? And she said, what are you talking about? She said, over the past decade, all the justices elevated to the United Kingdom's highest court are male, white, from private educations, and I'll add over 60, I think. So are those, given those demographics, is that set of decision makers going to give us the kind of public opinion or broad opinion that both Sir Robert and Don talked about can be so important in the law when we're asking questions that turn on public opinion? Is something misleading? Is an advertising misleading to who? To the public watching that advertisement. So I would leave you with a question based on what Sir Robert has said, what Don has said, and thinking about all the evidence that's been submitted to you. Is it not clear that judges need survey evidence in a wide variety of cases where they, given the definition, it's one person with your own specific set of characteristics, can you really answer questions that turn on public opinion? If it's done accurately, I submit to you, they need those public opinion polls. It will help them in doing their jobs, and it helps juries do their jobs as long as it's done properly. So thank you. I want to thank you all, for all three of us, Sir Robert, Don, and myself, for coming tonight. As I said, we're gonna adjourn for champagne in just a moment, but I would like to take a couple of questions, and I'm going to ask the first question of Sir Robert, just to get this going. We'll take a few more, and then we'll go to our drinks. But Sir Robert, so the first question for you is, you talked about public opinion polls and changes. So let's take Great Britain, whether it should exit the European Union. And you said that there were changes in the opinions as people were being polled. They weren't all the same as time went on. Do you believe that the fact that the public is being surveyed and those surveys are being published actually change or have some effect on public opinion? So when they find out, for example, when the voting, let's say it was the United States, when the voters find out that Donald Trump is getting a very high opinion rating, that people would vote for him, does that change do some other people come in and be more insistent or stronger in their views against Trump? But does the polling itself, can that affect the opinion polls the next time around?
Yes. And that's my first lesson, is don't ask a question that is bipolar, because all you get is one word, yes or no, and what you really want is an explanation.
Would you please explain that, Sir Robert?
Yes, indeed. There's no question about it. It does affect behavior, and there are a number of theories. In some cases, it's called a bandwagon effect, and that is the tendency of people to vote or behave in whatever way because other people do the same. They find out that this is the thing to do, so they want to jump on the bandwagon. There's also a boomerang effect, and between the United States and Great Britain, what you have is an interesting difference, that there tends to be a bandwagon effect in the United States, if any, and a boomerang effect. And for many elections, going back in the 13 elections that I have taken part in this country in my nearly 50 years here, even though I still talk funny, you have the opposite effect, because you can measure it by the result of the polls that are done the previous week of an election, and then the election result itself. And if it's close, then the people who, in this country, I'll use the phrase, although it's not accurate, feel sorry for the party coming lower, will move over to help them. And so that has an effect. Now, its most effect has been in the past, not this last election, where they were not decimated, but whatever the word for 90% is, would be, the liberals. Because the liberals are more likely to be voting for the party that they best think, in constituencies in which they're not going to win, they will decide who they want least of the others so that they vote for the other one. And that, it represents from 3 to 5% of the votes of liberal Democrats in past elections. So that's the best example that I can give you of it being effective, but it tends, as I say, to be more the boomerang effect than the bandwagon effect.
Fascinating. Questions from the audience? Anybody?
I'll ask one.
Yes.
I'm from the U.S., and I'm not a politician, I'm not a lawyer, so this is an unbiased question.
How unrepresentative of this group you are.
We're always taught as sales and marketing people not to talk about religion and politics. We're all bombarded in the United States by polls, opinion polls, by various universities, networks, etc. Who do we believe?
Did everybody hear the question? Okay. That's to Sir Robert, I believe.
That's a very good question. I think that you should examine the brand. If you know that a Gallup in the United States, a Pew poll in the United States, an Opinion Research Corporation poll, then you know that they have been going a very long time, all your life, in the case of Gallup and ORC, and they have proven that they carry out polls and their reputation is dependent upon it. And their reputation depends on their ability to stay viable. And so they're above all things. I remember very early on in my career here, I was asked, in fact, in the first year, asked to be the Prime Minister's private pollster, Harold Wilson. And there was a meeting of a group of senior leaders, both trade unionists, who were extraordinarily powerful in those days, and labor cabinet. And one of the trade unionists who on that National Executive Committee leaned forward and he said, now, I will understand if you don't feel you can answer the question, but which of the polls are bent? And I just laughed and I said, look, if there's any pollster that is bent, they'll be out of business in no time at all, because they'll be tested against other independent polling organizations in an election situation. And they'll be so conspicuously out of line that they're clearly suspect. Don was using a formula that I don't particularly like, because it's the standard plus or minus 3% in a sample size of 1,000 people, whether it's the Republic of Ireland with 3 million, 3.5 million people who are eligible to vote, the UK with 44 million, or the United States with 250 million or whatever it is. The size of the universe makes no difference at all. It's the size of the sample that makes the difference. And that is only representational. It doesn't allow for interviewer bias. And we tested, for instance, interviews done by Muslim interviewers of Muslims, and we found 25% don't know. Sorry, no, we found 10% don't know. Muslims interviewed by non-Muslims, we found 25% don't know. So they weren't going to be telling us what they thought, because they didn't trust the interviewer, because it was of a different religious behavior. Now, that is clearly evidence to me that that survey was suspect. I mean, that was a test for an article in Public Opinion magazine that we carried out at a time, some time ago, where it was a very important finding, I think, for all of us in the polling industry, to be very careful. Same thing in Trinidad, I mentioned before. We get questionable results, depending if there's a mixture. And in Great Britain, in Northern Ireland, we have the same problem, whether they're Catholic or Protestant. So it's very, very much will affect the statistical reliability of the standard statistical relationship.
So who can you trust is a very difficult,
Complex.
complex,
Yeah.
because you can't look at it on its face.
Well, and remember the subjective and the objective. He's over on the side now of, it was the questioner, all of these subjective factors. The formula applies only once you've got the data, but if the subjective factors are still in there, if it's that kind of survey.
Yeah.
Yes.
One more.
There was commentary, adverse commentary against polling for both the Scottish independence referendum and the last general election in the UK. And some wags suggested that the bookies had called it more accurately than the pollsters. So I was wondering if you could firstly speak to that.
Sure.
And then perhaps Don and Suzelle, you'd like to address whether you'd ever put the odds before court.
Yes, the wags are normally people in the booking industry. So that's the first thing. So look at the source of the critique. Secondly, that the most ardent viewers of opinion polls are the punters, because what do they want to do? A lot of them are gaming, and they're not necessarily betting on a projected winner as they are on whether the polls are going to go down or go up. And on a Saturday afternoon, I was online with a betting house, and I followed the bookies very closely. In the current situation, a month or so ago, they were the probability was 63% at that time, and it's the weight of the money that determines, once the thing kicks off, of what the probability is, and it's purely the weight of the money that they do these. And 63, 68, 72, 78, and now it's back down to 62 as the money shifts. But on that Saturday afternoon, I happened to be in a betting internet site where they were showing an hour by hour how that was moving. And at 4 o'clock, one of the pollsters released their Sunday morning poll to the media at precisely 4 o'clock. And I saw those hour by hour figures just shift immediately after that 4 o'clock release of that opinion poll. I'm terribly worried by the power of opinion polls, as I intimated before. And one of the things that compounds it is the gaming that people do. It used to be, no longer the case, because there's so many opinion polls now, that the city somebody in the city would leak a fictitious opinion poll that would actually, I remember one of them, a headline was, "This poll knocked 35 billion out of the stock market value," and it never existed. That poll never existed. But I haven't seen signs of that. I used to write about that all the time. I'm sure I've talked with David McKee at The Guardian about this problem in the past, and other newspapers, because I was so concerned with the fictitious gaming, and I'm still concerned about the actual gaming that has nothing to do with the outcome of the election or the outcome of the referendum.
I think
Let me
that,
just add one little footnote to that. In our country, the internet and the pollsters are so profuse today that I'm sure there are examples in there of intentional, malicious misrepresentation, but it's also, there's a Gresham's law at play here, because there's so many junk polls where they have taken a very small sample, maybe tried, but, asked a few questions, and these are published along with everything else and no explanation. And so one of the factors we've got here is so much information presented as polls that unless you knew the kind of things that Sir Robert indicated, the quality of the Gallup or somebody who'd been there, you see all these numbers, and it's just driving out, the value.
The pollsters themselves, going back to 1970, established a guideline that, and Alan's well aware of it, that we will not accept an assignment of a poll for the media with a sample size for voting intention of less than 1,000 interviews, because we were seeing in the United States 200 people. Now, the statistical reliability of 200 people, not out of 200 million, because that didn't matter, but in any sample of a national population in the world, really, even in Trinidad, it's the same statistic with or St. Vincent with 150,000 people, and you really have to have that kind of a pollster's law, a self-enhanced pollster's law, that we won't take the money that they do in the United States. Even good pollsters will go down to, I've seen 300. And I just think that's outrageous that they don't take that.
And not disclose.
Well, no, they do disclose the sample size, and we all do in both countries. The things that we insist upon the publication of, and sometimes I've had arguments with journalists who have left it out, the sample size, the fieldwork dates, the name of the polling organization that conducted it, and we have a rule of transparency that when that poll is released, we will within 24 hours release the full computer printout, and that includes the unweighted and weighted, which we haven't talked about, because no poll ever is exactly representative in the technical sense of the word.
So I know everyone's dying to continue this discussion, and we'll do it over champagne, but I'm gonna answer briefly the question, the second half of Tim's question. He said, would Don and I ever bet on the outcome of a case? And the answer is, of course we would. That's what the contingent fee is all about. So thank you, Alan. And are you going to tell us where we go from here? So everyone, for the champagne and further discussion on these fascinating topics, we're going across to Talbot Hall. We'll have drinks over there, and then most of us are coming back over here for dinner after drinks.
I have one more slide I must put up, and my thanks to Benjamin Thomas for his assistance on polling in the law. There you are.
And to James for his...
Oh yes, and to James Wallace, our LMH student who's been so kind to help us with the technology of this. Thank you. Thank you.